Every day in the USA, people find themselves in court.
Thomas Gillespie versus Jeff Smuda and others. Case number 2025 CV30. Elizabeth Fowler appears on behalf of the Department of Corrections. Mark Sievert is court-appointed counsel for the inmate Bradley Thomas Gillespie, who appears separately from his lawyer by Zoom. This matter comes before the court at this time for hearing regarding the petition in this case and the writ that was previously issued by this court requiring the state to respond. The court is aware of the verified answer and motion to dismiss that was filed in the case. Mr. Sievert, do you wish to make an opening statement?
Well, yes, Your Honor. Couple of things. One, we would object to the consideration of the state's response or the prison's response. The initial indication was that that would have been due 21 days after March 25th, and it apparently wasn't filed until October 30th. Secondly, Your Honor, we would ask the court to allow some discovery with respect to the case before ultimately having a hearing on it, particularly any photographs or measurements and so forth with respect to the cell in question and the alleged violation regarding the curtains in question. My client was also requesting discovery with respect to the other curtain DRs that were issued on September 25th to 24. He was also seeking to take some depositions of inmates and people who had been involved in the mass DRs. I understand that the court may limit some of the discovery, but it would seem to me that pictures of the cell and some of the measurements may be certainly necessary for your determination.
All right, your initial response, Ms. Fowler?
Well, Your Honor, I am, with respect to the timeliness, looking at that issue, I guess my response would have been with respect to my limited appearance regarding service of the writ, that we were not served with the writ properly. We weren't untimely. We responded timely after the writ was issued. So, Your Honor, I don't think that that's an issue that this court needs to take up. With respect to discovery, I don't think there is any contemplation by the habeas statutes for discovery in the manner that Mr. Gillespie is requesting. Furthermore, as far as any measurements of the cell, I don't think that there's any dispute based upon Mr. Gillespie's petition that he did have a curtain hanging in his cell. I'm not sure what measurements would or would not prove with respect to that, but I think that the evidence before the court, both in the petition and the responses, is that Mr. Gillespie did in fact have a curtain hanging in his cell.
Mr. Sievert, I at first glance would tend to agree with Ms. Fowler's assessment. Is that really a bona fide issue here as to what type of curtain and where it was in the cell? Isn't it fairly undisputed? And wasn't it at the time of the hearing that he did have a curtain in his cell? It's just it was away from the door. Wasn't that the point?
Well, yes, Your Honor, I think so, but I think it becomes pretty relevant with respect to the class of violation that they were trying to tag him with and how the interpretation would be by the court with respect to the curtain rule. It's my understanding that he was convicted of a more serious class of violation, a class 1 violation, which really we would submit has more to do with obstruction of the door versus a class 3 violation, which would be something more along the lines of probably what happened here, as far as there being some privacy sought near his bed. and it has more to do with the classification of violation and then the sanctions that are imposed as a result of that. Because the way it appears to me is that he was convicted of a violation of actually obstructing the door, and that's simply not what happened. And it may be a different issue as to whether or not he was guilty of some lesser infraction of just having a privacy curtain. But I think that's where it becomes important for the court's determination. And that's why I would think at least some, maybe the prison doesn't dispute the placement, but if there is a factual dispute with respect to the placement, it would be, I think, appropriate to have some of that available for you.
Well, all right. The court's understanding that really wasn't a contested issue, that the curtain was not on the door or any window connected with the door, correct?
I mean,
The interior of the cell, wasn't it?
that's my understanding of where it was, Your Honor.
Okay, well, I want Ms. Fowler to confirm that.
Oh, yes.
Yes, Your Honor. I don't think there's any dispute that in respect to this DR that's in question in this petition, that it was not on the door. However,
All
we
right.
disagree with the interpretation that the KR 12504 indicates that the only covering of the cell that is a violation would be the door to the cell.
All right. Well, I think Mr. Siebert has touched upon what appears to be a bona fide issue, which the court is next going to address, finding that there does not appear to be a material factual dispute here that would give rise to discovery, even if the court were inclined to allow it. But I have this regulation before me, Ms. Fowler. Interference with cell operation and visibility, subsection A. No inmate shall block or otherwise interfere with the operation of the cell opening and closing mechanism in any way, including food passage, ports, or slots. No inmate shall cover the inmate's cell, which is the way it reads, including food passage, ports, or slots as to block visibility into the cell, except as allowed by the warden's orders. Violation of this regulation shall be a Class 1 offense. Doesn't the language of 44-12-504 exclusively deal with the cell door itself?
Well, Your Honor, I think it focuses on the cell door because that is a primary concern, is seeing into the cell. But I think that it covers anything that would be covering within the cell and obscuring staff members' ability to see what all is within the cell. There is no expectation that there be privacy of any of our residents. And unfortunately, that is just one of the incidents of prison life.
All right. Well, this court is quite experienced in reading poorly worded statutes. Unfortunately, Ms. Fowler, there aren't enough lawyers in the legislature. And sometimes there is what the legislature intends and then ultimately what their statute says. And they're not necessarily the same thing. I'm looking at the language of this, and I don't see any reference to the interior of the cell, though it could have very easily have been included, such as no inmate shall cover the inmate's cell door, including food passage, ports, or slots, or otherwise in any other way block visibility regarding any other part of the cell. That would have certainly made it clear, wouldn't it?
I think it certainly could have made it more clear.
Well, so let me make sure I understand. I know that you're arguing what the regulation is intended to do. Fair enough, but what language in 44-12-504 supports that a curtain elsewhere in the cell, such as around the bed area, is covered by this particular regulation? What language?
Just the language, Your Honor, that sentence, no inmate shall cover the inmate's cell, which
What is that
includes,
supposed to mean? Cover the inmate's cell. You mean the entire cell? And
Your
how would an
Honor,
inmate cover the entire cell? I mean, who wrote this?
well, I can't take credit, Your Honor.
Okay. Or the blame in this instance, Ms. Fowler. Thank you. I appreciate that clarification. But again, that very same statute, or the very same sentence in the regulation says, no inmate shall cover the inmate's cell, comma, including food, passage, ports, or slots, which again refers right back to the door.
And Your Honor, I would just argue that it doesn't exclude any other portion of the cell specifically.
Okay. Well, I need to get some things in order here. Obviously, the court will allow the answer filed by DOC in this case, including any attachments or exhibits that might have been connected with that particular answer. So the procedural issue raised by Mr. Sievert, the court overrules. The court will allow it and consider it. Should this have been charged as a violation of published orders? And it does appear, and I don't know if this is disputed by Mr. Sievert, but based on what the court has read from the file, it appears that there was a published order in place that did deal more directly with blocking the interior of the cell. Is that conceded, Mr. Sievert?
I believe so, Your Honor.
Okay. So had he been charged and convicted under what would be 4412-1002, violation of public orders, it would be a class 3 offense, would it not?
That's my understanding.
Okay. Perhaps, Ms. Fowler, you could just clarify very quickly, what are the difference in penalty provisions between the class 1 sentence Brad Gillespie did receive and what the maximum penalties would be on a class 3?
Well, Your Honor, I do have that right in front of me here. So a class 3, maybe any one or a combination of following restriction to your own self from privileges for not more than 20 days. Let's see, work without incentive pay not to exceed 5 days, a fine of not more than $10, restitution of at least 3, oral or written reprimand.
All right. And I believe Mr. Gillespie did receive penalties in excess of that, did he not?
Your Honor, I would have to look at his.
I think he received a $15 fine. Did he not?
$15 fine. That's
Yeah.
correct.
And 30 days restriction.
Have those restrictions already been imposed and served?
Yes, sir. And fine has already been taken and everything too. And if I may add real quick,
You may.
I included in my exhibits, I included exhibit B, which was a similar occurrence. And that was a verbal warning whenever I explained this situation before, and I contested it with the same DR hearing officer. After I presented them cell house rules, he amended it, and I took that class 1, or I took that class 1 down to that published orders of a 1002, and that's when he gave me the verbal warning. So then this time came back around again under the same situations, which I wasn't disputing, but it's just the infraction that I got the enhanced conviction under the same scenario with the same people involved. So thank you for letting me add that.
All right. Mr. Sievert, I want to make sure that if you had any closing remarks, that you had the opportunity to make them.
Well, and I appreciate that, Your Honor. I think you understand from your questions and your comments very much so what the issue in the case is. And I guess the really, if we look at this from a strict charge conviction standpoint, I would submit that there's insufficient evidence to support the class 1 violation. I guess then it boils down to whether or not the court would, at this point, would be able to consider any sort of a lesser included or if there is even such a thing as a lesser included with respect to these regulations. But, he certainly was charged under the wrong regulation, and the facts do not support what the conviction was. So I would be asking the court to set aside the conviction of the Class 1 violation, and that there be a order of restitution to my client.
All right, very well. Ms. Fowler?
So, Your Honor, I haven't had this particular issue come up before. I would like the opportunity, if possible, to look at our policy regarding, I know that the court has the rules there, but our policy on cell appearance, just to make sure I'm not missing anything. I know that the section related to violation of policies or rules indicates that it's a Class 3 unless it says otherwise in the policy. So I just want to make sure that I'm not missing anything with respect to that. Otherwise, I wouldn't disagree with giving him the $5 so that $10 he's paid consistent with the Class 3.
Well, I think there's also the state of his prison record at stake here as well. I don't know what implications it might have for an inmate, but I trust it would have some implication. The court does find in this case that the court cannot find that Mr. Gillespie was in violation of what was stated to be his crime of conviction here, KAR 44-12-504. Rather, the court finds that there was no infirmity in the conviction proceedings, and that he was properly convicted in this case, but of a lesser included Class 3 offense of violation of public orders, and that his prison record is ordered to be amended to show that he was convicted of the Class 3 offense rather than the Class 1 offense, and that he be refunded any excess fine, which in this case appears to be $5. Ms. Fowler, I'm actually going to task you with drafting the order stemming from today's proceedings to document the court's orders. What's the noise there?
It was just a
Okay.
announcement here, sir. Sorry.
All right. And your relief, Ms. Fowler, should you discover that there's some other matter that you think you could have brought before the court, then you can file a timely motion for relief from judgment and bring it back before the court. But essentially what I'm just saying, changes records to Class 3 offense, a violation of public orders, refund the $5 that was fined in excess of the maximum amount that could be assessed on a Class 3.
Understood, Your Honor.
And now that I know Mr. Gillespie clearly knows the rules and that they're going to be enforced, I trust he probably won't have a problem with that in the future.
No, sir.
All right.
Your Honor.
Thank you, Your Honor.
All right. Anything further from counsel in the case?
No, Your Honor. Thank you.
Thank you.
Okay, I need to clarify something. Mandy, we're going to be on a different Zoom invitation for the next hearing. Is that correct?
That is correct, Judge.
Okay. All right. Then I'll see you in a few minutes, counsel.
Okay. Thank you, Your Honor.
Very well.
Thank you, Your
Gillespie
Honor.
matters in recess.
He hung a curtain by his bed, not on the cell door like they said. They slapped him with a Class 1 crime, but the wording didn't fit the crime. The judge read the rule and he shook his head. There aren't enough lawyers, the good judge said. So drop it to a Class 3, amend that line, and give Bradley Gillespie back his $5 fine.